Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with the update on the petitions filed by the Enforcement Directorate against Madras High Court entertaining a habeas corpus petition which challenges the arrest of Tamil Nadu Minister Senthil Balaji and allowing him to be shifted to a private hospital for medical treatment. The Supreme Court vacation bench, comprising Justice Surya Kant and Justice M.M. Sondaresh, today adjourned the hearing of the petitions in view of the fact that the Madras High Court is set to hear the matter tomorrow. Solicitor General of India Tushar Mehta argued that habeas corpus petition was not maintainable against arrest by an authority in accordance with law. He further argued that the interim order which allowed Balaji to be shifted to a private hospital meant that the ED's remand was meaningless. The SG also cited various decisions of the Supreme Court according to which police remand cannot be given beyond the first 15 days of arrest, and so the period of hospitalization should be excluded from the first 15 days. But the bench refrained from considering this plea, saying that the High Court was considering the matter and entertaining the petition should not be confused as holding the petition maintainable. The bench refrained from passing any substantive orders. You can read the entire courtroom exchange on livelaw.in. If you remember, yesterday I told you about the interlocutory application filed by the District Panchayat of Kannur seeking permission to euthanize suspected rabid or extremely dangerous dogs in light of the increased violent attacks by stray dogs in the district. The application was mentioned before a vacation bench comprising Justice Surya Kant and Justice M.M. Sondaresh, and the court has decided to hear the matter on 12th of July. Stay tuned. In another update, the Tamil Nadu government has told the court that under Article 122 of the Constitution, the Speaker is empowered to take a decision on what part of the Legislative Assembly proceedings can be telecasted, and the same cannot be questioned by the court. The Advocate General R. Shanmuga Sundaram made the submissions before the bench of Chief Justice S.V. Gangapurwala and Justice P.D. Odi Kesavulu in a plea moved by State President of Lok Satta Party and leader of DMDK seeking live telecast of proceedings of the House. SP Velumani, Chief Whip of AIADMK Party, had also filed an impleading petition challenging the selective telecast. Senior counsel Vijay Narayan, appearing for Velumani, argued that even though with all advancements one could view the proceedings in Lok Sabha and Rajya Sabha, but in Tamil Nadu only edited videos of the proceedings were being shown. The Advocate General submitted that the question hour was being telecasted live since January 2022 and discussions on important resolutions, call for motions were also being telecasted live since April this year. He further submitted that edited footage of all businesses of the House were also provided to media channels a few hours after the assembly proceedings. The court questioned as to why proceedings of the House could not be shown at the end of the day after editing only the expunged remarks and sought to know whether a proposal for the live telecast of speeches made during the 0 hour was under consideration. The case will now be heard on 26th of June. The Delhi High Court today refused to advance the hearing of a petition seeking removal of alleged objectionable scenes in the movie Adipurush. The petition against the movie is tentatively listed for hearing on June 30th. The petition argues that Hindus have a particular view of the image of Lord Ram, Sita, and Hanuman, and any change or tampering of their divine image by the film producers, directors, and actors would be a violation of their fundamental rights. It argues that the scenes show the religious characters in a bad taste and are an absolute insult to Hindu civilization and Hindu religious figures. The court, however, refused early hearing of the matter, saying that the film had already been released and that it was not convinced about the urgency. The Kerala High Court today directed the jail superintendent of the district jail at Kakanad to produce all the medical records of the former Principal Secretary to the Chief Minister of Kerala, M. Sivasankar, on his plea seeking interim bail for 3 months on grounds of ill health and to avail treatment at a private hospital of his choice. As you know, Sivasankar is in custody in connection with the Life Mission money laundering case since his arrest by the Enforcement Directorate in February. Justice Kausar Edappagat today orally remarked that if the records revealed any medical emergency, bail would be granted to the petitioner. The matter has been posted for further consideration on 27th of June. The Rajasthan High Court has ordered the release of retirement benefits to the legal representatives of a retired audit inspector from the cooperative department who died in between of his years-long battle with the state over withheld pension. A bench comprising Justice Anup Kumar Dhan noted that the deceased had a clean service record and yet his pension was withheld, citing delay in obtaining his records from one of the departments where he had once served. The court also imposed a cost of Rs 50,000 to be paid to the widow of the deceased. The Karnataka High Court has quashed the FIR lodged against a man by a married woman complaining that she was cheated by the man as he failed to keep his promise of marriage to her. A single judge bench of Justice M. Nagprasanna quashed the FIR and said that the complainant had admitted that she was already married and had a child from the wedlock, so there could be no question of cheating on the breach of promise of marriage. In this case, the petitioner argued that he did help the complainant when she was in dire need. The court said that merely because the petitioner had sent some money for the need of the complainant, it did not mean that the petitioner had to maintain them without a legal bond between the complainant and the petitioner. The Calcutta High Court today directed the state of West Bengal and its transport department to form a committee to examine and submit a report as to how tram services can be restored, maintained, and preserved in the city of Kolkata. The bench comprising Chief Justice Sivangnanam and Justice Ajay Kumar Gupta passed the order in a PIL for preservation of remaining stretches of tram railways in the city from being sold off or demolished. The bench also asked the state to not treat such a litigation as adversarial. And now let me tell you that the lawyers community in Jammu is up in arms over the proposed relocation of the Jammu and Kashmir High Court to Raika. Lawyers from the Jammu and Kashmir High Court Bar Association Jammu have resolved to stage a protest in the national capital if their concerns were not addressed. The lawyers argue that shifting the High Court complex would cause severe hardships for both legal professionals and the general public. The Young Lawyers Association Jammu has also stated that the existing Janipur location provides ample space for expanding the court premises, rendering the shift to Raika unnecessary. Authorities say that relocating the High Court building to Raika would improve infrastructure and accessibility. However, the lawyers said that the Lieutenant Governor Manoj Sinha had guaranteed not to shift and displace the existing court premises. The Punjab and Haryana High Court has stayed the notification issued by the Secretary of Punjab Department of Local Bodies, which removed Councillor Rajpreet Singh from Municipal Corporation Morinda. Singh, a Congress party representative, was removed from office for allegedly misusing his position and causing financial loss to the council by using the official vehicle for personal use. Justice Pankaj Jain issued a notice to the respondents and stayed the notification. The matter has been posted to 12th July for further consideration. Stay tuned. And lastly, the Karnataka High Court has issued notice on a public interest litigation seeking directions to the state government to constitute Heritage Conservation Committee, Metropolitan Planning Committee, and Grievance Redressal Authority as prescribed under the BBMP Act of 2020 for proper administration of Bengaluru City. A division bench of Chief Justice Prasanna B and Justice M.G.S. Kamal issued notice returnable within 4 weeks on the petition filed by Advocate Ompathy S. The plea states that the BBMP Act provides for the orderly growth of Bangalore with power to take action against erring officials responsible for illegal and unauthorized constructions. However, construction of the Metropolitan Planning Committee under Section 367 of the Act has been neglected by the government, which is mandated to prepare a draft development plan for the entire Bangalore metropolitan area. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.